So we have some important news in the current efforts to remove suppressors and short-barreled rifles from the NFA nationwide. 15 states recently joined this effort to end the NFA's current restrictions, and also the court in this challenge just struck a major blow to the ATF and their current attempts to stall this case. So let's break down what is happening in this critical challenge. Now, before we jump into this video, if you guys want to support the channel, one of the best ways to do that, of course, is to subscribe to the channel. Also, double check to make sure YouTube has not unsubscribed you. And then also we have another feature here on the channel where you can become a channel member. I believe that's like $4.99 a month. It's the lowest that you can charge actually to become a member. And with that, we have some additional features, and we're probably going to be doing some additional things for the members only. So as I mentioned in the intro, in this video, we need to talk about a critical lawsuit against the NFA and all of its remaining restrictions in the attempts to remove the NFA's restrictions on SBR, suppressors, and all of these other items. Now, this lawsuit comes in direct response to the One Big Beautiful Bill, HR 1, that was passed, and the removal of the NFA's tax, changing the tax from $200 per stamp all the way to $0. Now, in this effort with the One Big Beautiful Bill, you guys know that we tried to get things like the Hearing Protection Act passed and the Short Act and the full versions of that bill that we wanted here in the One Big Beautiful Bill, which would completely deregulate these items. But unfortunately, rhinos in Congress were unwilling to press that issue and get the full versions of the bills that we wanted included in the HR 1. And also, they were unwilling to remove the Senate parliamentarian, who was responsible also for striking out the full versions of the language that we wanted. Now, also in response to this, recently we saw how Democrats responded. The senators like Chris Murphy introduced proposed amendments to the military spending bill, which would increase the NFA's tax requirement to $4,709 per stamp. So Democrats took immediate action in response to the NFA tax change, but now also multiple toy organizations are also launching lawsuits to remove all of these remaining restrictions and do away with the NFA outright. You had GOA, FRAC, Silencer Shop, Palmetto State Armory, Silencer Co., and others who filed a lawsuit against the ATF. And also you had 15 states recently join in support of this lawsuit and become named plaintiffs against the ATF. Now, if you're interested, those states who joined this lawsuit are Texas, Alaska, Georgia, Idaho, Indiana, Kansas, Louisiana, Montana, North Dakota, Oklahoma, South Carolina, South Dakota, Utah, West Virginia, and Wyoming. So those are the states that joined this challenge. And now this coalition of toy organizations and states are moving to end the lawsuit and end all these NFA remaining restrictions immediately. So in this lawsuit filed by these parties and these plaintiffs in these states, they are actually seeking a summary judgment to end the case right here and now. They argue that since there is no longer a tax on these items like suppressors, SBRs, SBSs, and AOWs, there is no longer a valid constitutional basis to further regulate these items under the NFA. In summary, what GOA and these other plaintiffs asked for in this challenge is for the court to declare that the NFA's registration and transfer requirements pertaining to all of these now untaxed items goes beyond Congress's enumerated powers. They asked for the court to enjoin all of the ATF's employees and agents from implementing or enforcing the NFA against these now untaxed firearms. Then moving to the Second Amendment arguments, they also state that the challenge provisions not only exceed Congress's enumerated powers, they also infringe on Americans' enumerated rights. The Second Amendment, they state, protects the right of the people to keep and bear arms. The firearms at issue here undeniably are arms under the term's plain meaning. Under Bruin, that means that the NFA's regulations are presumptively unconstitutional, and the government bears the burden of proving the constitutionality of its actions. To satisfy that burden, the government must demonstrate that its regulation is consistent with this nation's historical tradition of firearms regulations. The government must identify a broad and enduring founding era tradition of historical analogs with a similar how and why, underlying the modern law's burden on a law-abiding citizen's right to armed self-defense. Here, however, they state, no historical tradition supports registration requirements for arms in common use, such as the weapons at issue here in this case. So that is what the new lawsuit aims to do in response to the NFA tax change that was passed in HR 1. And now the plaintiffs also filed a motion for summary judgment to end the case sooner rather than later. So what this means is that actually the plaintiffs and the ATF both filed cross motions for summary judgment, and they're seeking to end the dispute sooner rather than later and end this before it goes to a full trial. However, the ATF also in response attempted to recently stall this case and stall this challenge by claiming that the government shutdown actually prevents them from filing the response and moving this case forward. And based on that, they asked kind of for an indefinite hold on this case until the government shutdown ends. But in an interesting turn of events, the court has actually now issued an order and responded to that request. And the court here actually denied that request of the ATF. The court denied the indefinite delay of this case because of the shutdown and instead gave the ATF just one additional week to file the response in this NFA case. In the order of Judge Hendricks, he stated that the court denies the motion in part. Federal shutdowns typically do not prevent the Department of Justice's attorneys from working when a court denies the government's motion to stay. That said, the court is mindful of the need for detailed and careful briefing in this matter, which includes a Second Amendment claim. The principle of party presentation is critical as it gives the court a solid foundation upon which to rule and prevents reliance on weak or irrelevant evidence. Accordingly, here, the court will give the defendants an additional week to respond. The defendants must submit their combined response to the motion for summary judgment and cross motions for summary judgment on or before November 13th, 2025. All other deadlines remain in place. So that is a strong move here by Judge Hendricks, who is in charge of this case. And that's, a strong move because we've seen already some other courts agree to delay some of these challenges based on the government shutdown. But here, the judge pointed out that through a court order in the denial of that request to stay the case, the government can be ordered to move forward and actually be required to work. And that's exactly what he's doing here in this challenge. So what this means for the big, beautiful lawsuit here going forward is that both sides are moving to end the lawsuit sooner rather than later. And the ATF wanted to delay this case, but now they are ordered to continue to work on this case and file their response by mid-November. It will be interesting to see how the Trump ATF now responds to this challenge. And we've seen that the Trump DOJ recently defended multiple NFA, restrictions in different cases, like the Rush case and the Robinson case in front of the Supreme Court. In both of those challenges against the SBR restrictions under the NFA, you had the Trump DOJ defend that. We've also seen the Trump DOJ defend things like the Gun Control Act in cases like Morgan and Brown. Those cases are in front of the 5th Circuit and the 10th Circuit. So in both of those cases, we've seen that the Trump DOJ is defending the NFA and the GCA, and I anticipate that they will do the same thing here in this challenge. So there's a lot of moving parts now in the NFA battles. Lawsuits have been launched, and now Democrats are also trying to do their own attempts to increase the NFA tax. We have seen cases in district courts, courts of appeals, circuit courts, and now also you have 2 cases in front of the Supreme Court as well seeking review. So again, it's going to be interesting to see how the Trump administration responds to this case now that their attempt to delay the case was denied and they have to file that response. So that's what's currently going on in this critical NFA challenge, which is trying to build off of the $0 tax change that was passed in HR 1. As we get more information, as this unravels more, I will let you guys know. If you like this video and you'd like to support the channel, one of the best ways to do that, of course, is to like, comment, and subscribe. All those things help to fuel the algorithm, help the channel to grow, and tells the algorithm that you appreciate this type of 2A content. Also, like I mentioned, if you want to support the channel even further, you can become a member of the channel. There's a join button down here on the screen. So if you're interested and you want to become a member of the channel and contribute to the channel, you can click and join and become a member. But as always, thank you guys so much for all of your support. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.